Hello, good evening and welcome to UPfront. You just heard the Attorney General of the Republic of Ghana, Dr. Acquah, explaining to the People's Republic why he has recently been on an important quest to not only withdraw, but file nolle prosequi in some of the cases. And he took some time to go through some of them. Of course, the popular ones like the Republic versus Stephen Opuni and another. In studio joining me now, of course, we knew this was likely to happen today. So yesterday or the day before, the minority in Ghana's parliament had put up a press conference. That press conference was geared towards getting the Ghanaian people to understand that the conduct of the Attorney General is not acceptable. A man who is a lawyer, and a lawyer representing the good people of Mensia South, and I call him the Ashtown MP, is my guest, Nana J. Bafwa. You're welcome, sir.
Thank you, my brother.
I hope you are doing well. He's here because he was one of those who were insisting that the Attorney General is just embarking on a nolle prosequi spree, or if you want to call him a clearing agent of different sorts, in this particular engagement. So Nana J. Bafwa is already in studio with me. I hope you are doing well.
Oh, by the grace of God.
Let's start on this note. First, when he commenced this conversation, the Attorney General stated to everybody in the Republic of Ghana, he disagreed with the Supreme Court position that said when they file nolle prosequi, they are not entitled to explain that to anybody. That is the reason why Dominic Ayine came on this show today. What's your view on that in the first place?
First and foremost, let me make this preliminary statement. Because there's a bit of, if you like, discontent in the system, against the previous administration. Mm-hmm. Sometimes when you raise very pertinent issues about the current government, people think that you just want to distract the government. No, that is not our position. We believe that as Ghanaians, we have to assist the government to embark upon its objectives, govern well, so to the benefit of Ghanaians. And so when we raise these issues, we are not interested. It's not because we want to distract the government or settle scores. There's no score to settle. If the government does well, it does well for all of us. Now, having completed that preliminary comment, I wish to state that Dr. Dominic Ayine has confirmed to me that he's indeed a gentleman. I've always had, he's always been somebody I respect. I've never shied away from stating that fact. Okay. I've always, admired his principled position, his courage to take principled positions and defend them. And so today, having come out to address these issues, he has indeed confirmed or enhanced the kind of respect I have for him. It is on that score that he's not afraid to take different positions, even from the apex court. Okay. And so in that regard, we are on the same wavelength. My position has always been that the power of the Attorney General to file nolle prosequi or withdrawal, right, is discretionary and consistent with Article 23 and 296 of the 1992 Constitution, particularly in cases of this nature where there's so much public interest. The public ought to know why certain steps are being taken. And so for me, he has earned my respect in that regard. And I salute him for the position he's taken, which is contrary or different from the position of the Supreme Court. Perhaps the Supreme Court may be guided in the future when such a case comes before them, or a case where people are demanding for an explanation as to why the AG has filed nolle prosequi or withdrawal, right? Because the Supreme Court is also free to depart from its previous decision. And so in that regard, he has earned my respect.
Now, let's drill down to some of the cases that actually took center stage in this conversation. One of those is that on the banking trials. In two of the banking trials, according to Dr. Ayine, he took the decision to withdraw the charges against Johnson, Pandit, Esiama for the simple reason that in the course of the review of the cases, his attention was drawn to an internal memo prepared by the Prosecutions Division of the Department for the attention of the former Attorney General, which recommended that the charges against him be dropped. In fact, he notes that that's an important note that ought to be pursued. So we can listen to him, and we'll be joined also in studio by lawyer Raymond Acquah in a second.
In two of the banking trials still ongoing, I took the decision to withdraw the charges against Mr. Johnson Pundit Asiama for the simple reason that in the course of my review of the cases, my attention was drawn to an internal memo prepared by the Prosecutions Division of our department for the attention of the former Attorney General, the Honorable Godfrey Yeboah-Dame, which recommended that the charges against him be dropped. This is very significant. This is an internal memo prepared by professional prosecutors advising the Attorney General that the charges against our current Bank of Ghana, the Governor of the Bank of Ghana, be dropped. Note that Mr. Johnson Pundit Asiama was charged with contravention of the Banking Act for granting a facility of 300 million cedis to Universal Merchant Bank and for causing financial loss to the state in the sum of 150 million Ghana cedis. The internal memo, which I just cited earlier, concluded as follows. This is very instructive. It says, a study of the facts of the case indicates that the initial facility of 300 million has been recovered, leaving 150 million outstanding. This office has confirmed from the Bank of Ghana, that is, the Attorney General's office has confirmed from the Bank of Ghana through Mr. Alexander Tarr, that is PW2, prosecution witness 2, that the interest from the outstanding amount is presently being serviced by UNB Bank.
So his justification is quite clear, and let me start with you, Nana J. Bafwa. Do you support that decision to drop those two cases against the current governor of the Bank of Ghana, Johnson Pundit Asiama? Of course, he said there is already a memo from the Attorney General's Department that suggested that and recommended that the charges against him be dropped in the first place. So he had no business continuing when that was in existence.
Okay, thank you very much. I disagree with his position. And before proceeding, let me say that in an earlier conversation, I'd made the mistake of saying that there was a charge of conspiracy preferred against Mr. Azibit.
Okay.
I confused that with some other accused persons. There's actually no charge of conspiracy against him. So I want to withdraw that. Mm-hmm. But the two charges against Mr. Johnson Asiama, right? One is for breach of fiduciary trust. One is for breach of fiduciary trust, and the other is for willfully causing financial loss to the state. Now, let me share with you the brief facts of that.
Very briefly.
No, it's very brief. Particulars of offense. It says breach of fiduciary trust, contravention of the Bank of Ghana Act 2002, Act 612, contrary to Section 46H and 667A of the Bank of Ghana Act 2002. This is the first charge against Dr. Asiama in the case of the Republic versus Dr. Dufo, Unibank, and 9 others.
Okay.
And 8 others, sorry, of which he was an accused person. Now, the brief facts are these. Johnson Pundit Asiama, in or about September 2016 in Accra, in the Greater Accra region, granted a facility in the sum of 300 million to Universal Bank for the benefit of Unibank Ghana Limited. This is it. 300 million to Universal Bank, Merchant Bank, for the benefit of Unibank Ghana Limited, without satisfying the prescribed conditions set out in the Bank of Ghana Act. Let's break it down. Because for every offense, right, there are elements that you need to satisfy. And so for the prosecution to succeed in the prosecution of this matter, the first element they needed to establish is whether or not the period in question, Mr. Johnson Asiamah indeed advanced a loan of 300 million to UMB for the benefit of Unibank Ghana Limited.
Okay.
That's the first element. That's the first element. So when the Attorney General was speaking, he said it was an amount of 350 million, right? Of which 200 million was in the case of UT and 150 was in the case of Unibank. No. The facts as filed by the AG's office, the charge sheet as filed by the AG's office in the Unibank matter shows otherwise. It shows
so can I know you're making the point, but can I just read to you his conclusion? Yes. He quoted a certain memo which actually said they should drop the case, right? That memo said, a study of the facts of the case indicates that the initial facility of 300 million has been recovered, leaving 150 million outstanding. The office has confirmed from the Bank of Ghana through Mr. Alexander Tar, PW2, that the interest from the outstanding amount is presently being serviced by UMB Bank. Mr. Tar also indicated that UMB has an account of 150 million locked up with the CBG. It is expected that when the sum is realized to UMB, the loan amount for which A3, that's Johnson Pandit Asiamah, was charged with causing financial loss, will be repaid to the Bank of Ghana. This therefore may render the charges proffered against A3 moot, leading to a discharge.
The first point we need to know or make is that the charges against him is not only willfully causing financial loss to the state.
Okay.
There's also a charge of breach of fiduciary trust. There's also that charge. That charge is not hinged, or the success of that charge, all right, in terms of the prosecution, it's not dependent on the recovery of the amount or not. No. It says that he breached provisions of the Bank of Ghana Act, right? He breached provisions of the Bank of Ghana Act because there are conditions he needed to satisfy in advancing the money, which he didn't satisfy. The AG did not address us on that, conveniently. What is the opinion of the prosecutors on this matter, on this particular charge? Because, for me, it is very important that we get to know the position of the Attorney General on this particular charge, which he conveniently omitted in terms of his address, because the man is now at the Bank of Ghana as governor. If as deputy governor, he was breaching very important provisions of the Bank of Ghana Act, what is he going to do as governor? It's very, very important.
Okay. But now that it has been dropped, we don't even know whether it happened for real.
No.
Because that was the position of the prosecution in the first place, but it has been dropped.
But there is no, he never commented on this.
Okay. Let me bring Windorf into it. I think that's preliminary. Let me.
No, wait.
Okay.
He will come in. See, we need to make the point that the AG, the view taken by the AG, was based on an opinion given to him on one of the charges.
Yes, not the two.
Not the two. And so the sustainability of the other charge in terms of the prosecution, right, we still don't know.
Okay.
Do you understand?
I get your point, yeah.
Now, as to whether, I've also spoken to Godfrey Dami. He tells me that there is no such opinion, such memo.
Really?
Yes, Godfrey Dami tells me that the only memo that was written to him, this is what Godfrey Dami told me, that the only memo that was written to him was a memo to the effect that he must separate, right, some of the accused persons, right, and pursue their charges separately, because putting them together makes the prosecution difficult.
Okay.
But the point also needs to be made. The point also needs to be made that whenever the prosecution or the prosecutors gives you a memo on a matter, right, you are the Attorney General, you make the final decision, and not the prosecutors.
I get your point. Okay, so Randolph, he says this opinion, even if it existed, was just for one of the charges. The other one was not actually explained to us why the AG dropped it.
Well, Raymond, good evening to your viewers. I find the position taken by my learned friend very difficult to accept because, first and foremost, we have not cited the memo that the Attorney General made reference to. So we cannot go into the contents of the said memo. But having made that point, I would prefer to rather err on the side of the Attorney General and the existence of the memo and what it entails. The Attorney General has informed us that there is a memo, and the memo advised against the prosecution of Dr. Asiamah. Until the contrary is proven, I think we should stick to that. That is be my preliminary comment on that. Until my learned friend is saying that Godfrey Dame has said. Godfrey Dame was the one that this memo was addressed to. He never made it public until now. He never even talked about it until now. So where is this statement from Godfrey Dame coming? I mean, it's not something that we can even verify because it is not a written document. That having been said, prosecution is a discretion. Attorney General comes and says, based on the content of the docket before me, I have cited an advice which says that I should not continue with the prosecution of A, B, C, D. I have reviewed the docket, reviewed the evidence on file, and I take the view that the continual prosecution of Dr. Asiamah would be against Article 296. That it would be unfair. So I have discontinued. And don't forget, that is also a power, an unquestionable power given to the Attorney General. Okay. The Attorney General had no obligation to even come and tell us why he discontinued. He just thought it right to do so.
Okay.
That's all.
Of course, today he stated that he disagreed with the Supreme Court on whether or not he should continue and that he believes that he should tell the people the differences in there. Now, of course, I asked for his opinion on that. What do you think about that? Some say you're just opening the floodgates, that every single decision that you make as Attorney General, that's come and justify it to us. Others are saying that is how true democracy works.
I don't think it will relate to all decisions. I think that...
If I even said that in some of the cases, he may just issue a statement in explaining that.
Yeah, he said, I overheard him say that it may not continue like this. There are some cases that they will just send the explanation to maybe the judge, or they will just write and tell the people we discontinue for A, B, C, D reasons. So I think on that note, he wants to set a different administrative path.
Okay.
He's not under any legal obligation to do it. I think that it serves his own conscience right for it to be done that way. So at least the Ghanaian people on whose behalf he's conducting prosecutions addresses why he's going on with case A and why he's not going on with case B. We may differ in opinions as to whether we agree with him or not, but at least he would have given us the basis for his decision.
I did also hear the bit to do with the breach of fiduciary, what they call a role. Duty. Did you really...
Fiduciary trust.
Did you get the response to that?
I have not cited the charge sheet.
Okay.
I have not seen the facts. But as my learned friend knows, the facts of the prosecution is not the facts of the case.
Okay.
Because the prosecution may present a case. Okay. It is the evidence that will give us the facts of the case. My learned friend has just showed me, so if I may just look at it.
That's the first charge.
Because his contention is that why then did you isolate the issue?
No, so what my learned friend shows me doesn't talk about trust.
Okay.
Because I've not looked at a particular section. It talks about a breach of a particular provision of the Bank of Ghana Act. Bank of Ghana Act. So we don't know whether that act talks about trust or not. But even if it does, it still doesn't change the fact that this is the position of the Attorney General, which he said he took based on advice from the prosecutor in charge of the case. Which was contained in a memo he inherited. So I would want to stand by that until the contrary. I mean, Attorney General Godfrey Dame has every right to come out and tell us that that is not true.
That he never saw any memo.
He can come out and then tell us that there was no memo like that.
But he said he told him that.
No, I mean, that is hearsay.
Okay. So you want to out there telling us more about that?
Exactly.
There's another issue. Yes, if you want to quickly speak to that matter.
I'm your learned friend.
I'm not disputing.
No.
I'm not disputing what my learned friend is saying. What I'm saying is that long as Godfrey Dame is alive,
let's make it the point.
So long as Godfrey Dame is alive, he's within this country. A press conference has been made. His name has been referenced. If he has objections to it, he should come out and clear it.
Okay.
Wait. The memo is said to have been written to Godfrey Dame and not written to the current Attorney General.
True.
But obviously, because he's taking over,
he will get access to documents.
He's supposed to get access to it. And so if Dame tells me that it is not true, right, because I spoke to him for confirmation, right, I'm inclined to believe him. Secondly, Dame even says that the only memo had to do with, breaking down the trial, right, separating the accused persons to make the trial easier, okay? That I've also hammered the fact that the Attorney General himself, right, is supposed to form his own opinion.
Okay.
Because, look, we all know there are views that...
he actually says he agrees with the memo and the position that the memo took.
But
he said in the statement.
But there are two charges.
Okay.
There are two charges.
Oh, yeah, you made the point about the charges.
Two charges. He only spoke to just one charge. He only spoke to just one charge. And that, for me, is problematic. So you came to the conclusion based on one charge? Are we saying that for the banking crisis of this country, no official of the Bank of Ghana, no official of the Bank of Ghana will be held responsible? Look, should
there necessarily be somebody being held responsible?
Of course.
From the Bank of Ghana?
Yes.
Because he has not discontinued the case in relation to the other people anyway.
He was the only person from the Bank of Ghana who was charged in respect of this matter. The only person. In the UT Bank matter, he's the only person. In the Unibank matter, he's the only person. Now, my brother, we are building a nation. I admire the position which has been taken by Dr. Dominic Ayeni, which is to come out and give us a reason why he filed the nolle prosequi. I respect him for that. This is what is required in nation building. I have always held the view that for nolle prosequi or the decision of an AG not to continue with a criminal matter, and a reason is required. And invariably, my learned friend will agree with me that if you are an accused person standing trial, one way or the other, you will know why the matter has been discontinued. The AG might tell you, I'm not interested in pursuing this matter anymore. That is a reason.
Yeah.
The AG might say, I'm withdrawing just so I can, replace the charges.
Yeah.
That is a reason. And so invariably...
Which is what he's at liberty to do anyway.
Which is what he's at liberty to do. And so invariably, if you are standing trial, in practice, you know the reason why it has been discontinued. It is only when it comes to the national stage that you oftentimes hear that the AG does not owe us an explanation, which is what I think is wrong.
Okay.
Because that is an administrative office. And being an administrative office, the AG is not above Article 223 of the Constitution and 296. And the Attorney General, in his press conference, made reference to this and agreed to the position which I have canvassed all this while.
I want to ask you, forgive me, because they say my time, I have barely 10 minutes to conclude this conversation. The other important part, which of the other cases the man outlined, do you think that you do not accept the justification he has given so far? He talked about Opuni. He also talked about, of course, Opuni has been very topical in the country. He gave several reasons why Opuni's own is quite problematic. He also talked about the Collins Dowda case, and he mentioned others. Sorry, I'll come to you.
So, the Saglemi matter.
Yes, the Collins Dowda one.
His problem is that the charge sheet is defective.
Yeah.
Because the amount which is stated as having been lost, right, he does not think is correct because some houses have been built. And so they ought to have, in a nutshell, done evaluation of the amount spent and deducted that from the amount, given, and come to the conclusion that this is how much has been lost, rather than stating the entirety of the contract sum as having been lost. In other words, because there are houses which have been built, you cannot say that the entirety of the contract sum has been lost. That is his argument.
Yeah.
Good. So he does not dispute the fact that some amount has been lost, except that you cannot say that the entirety of the contract sum has been lost. So how much have been lost?
I don't think I agree with my friend on that.
No, but if he finishes the point, sorry, forgive me, I will let you come in.
So how much has been lost?
Okay.
How much has been lost can be determined through proper valuation. And so if it is the amount which is stated on the charge sheet as having been lost, which you disagree with, it doesn't make the charge defective. Or even if you agree that, even if you say it is defective, it is curable through amendment of the charge sheet to put down the amount which has been lost. Unless you want to say that no money has been lost from the Saglemi project.
Okay, that's interesting.
If you say, if your position is that no money has been lost in the Saglemi matter, that is different. If that is your position, if the AG's position is that no money has been lost in the Saglemi matter, that is different. As opposed to you saying that it is not the entirety of the contract sum which has been lost.
Okay.
Now, if indeed some amount has been lost, then indeed there is a case to be answered, except to say that a case to be answered for a lesser amount. That lesser amount, you cannot determine it unless there has been valuation. That in and of itself does not make the charge sheet defective to the extent that the charge is unsustainable.
Raymond.
So now, I happen to be on the Saglemi matter.
Okay.
As one of the defense attorneys.
Okay.
So
they are all conflicted.
No.
All of them are conflicted.
So let me allow the man to speak to them.
All of them are conflicted.
I want to hear you.
Hence the position they've taken.
I want to hear him on this matter. Yes.
Saglemi, like the Leonard Attorney General said, it's a very complicated matter.
Okay.
Because Saglemi, we went for a loan of 200 million. What people fail to understand or appreciate is that at the time Honorable Collins Zauda assumed office, $80 million of that money had already been dispersed under E.T. Mensah. The evidence on record also shows that about $10 million or $50 million was dispersed by Honorable Attachia.
Okay.
Yet you charge Collins Zauda for embezzling $200 million.
Especially when there were monies dispersed outside or before.
The Attorney General's records, I'm speaking to the Attorney General's own records, show that monies were dispersed before Collins Zauda and after Collins Zauda. So then how do you charge him with a complete sum?
But it's just about numbers. Can't that be rectified?
I'm coming. So you see, what we have to understand is that the power to prosecute is discretionary and requires that it must be exercised fairly. So if an Attorney General picks the docket, reviews it and takes the view that these charges were not preferred fairly, he has a right to right that wrong and possibly start the system all over again.
Oh, okay.
Do you get it? Because you cannot go to court when the facts... What is this? You said Honorable Collins Zauda supervised the payment of monies. His successor, Attachia, supervised the payment of monies. But in the two scenarios, you charge Collins Zauda, you leave Attachia. Okay. So is that a fair exercise of prosecutorial power? So the Attorney General has looked at it and taken the view that no, in this instant case, looking at the nature of it, it is not fair. So I have discontinued it. What he may decide to do later, he has not told us.
Okay.
So I don't see why we are going to...
In fact, he had indicated that he's not left the Saglemi matter.
Yes.
And it's a matter that he would actually take up in due course. But he wanted the facts straightened. That's one of the things that he said. Yeah. But Nana, you have a response to that very briefly.
The reason given by the Leonard Attorney General for discontinuing Saglemi is not the same as what my friend is given here.
No, Raymond has just confirmed what the Attorney General actually said.
You are referring to...
No, he said he's not even done with that matter. He'll come back to it.
A certain disbursement done prior, before, after he took office and subsequent to when he left office. Yeah. That's what you're referring to. But I'm saying that is not the reason given by the Attorney General.
It's implicit in the reasons he gave. That you cannot charge one person with the entire sum. When disbursements were made before the person came into the office.
You see.
So that goes to show, my learned friend, that goes to show the unfairness.
Today you call me your learned friend.
Okay.
No, but
that goes to show the unfair exercise of prosecutorial power by the former Attorney General.
He's my younger brother.
No, I get your point, but
calling me your learned friend.
Okay, let me bring this point in. No, so he says here the prosecution in this case also failed or neglected to take into account payments that were made by other ministers who took office after the Honorable Collins Zauda. For instance, Attachia as minister paid to the tune of $5 million in 2017. And he moves on. But there was another, the first one he stated was that the first reason he gave, which is here. He says, in the case of Collins Dowda, the first accused was charged with misapplying property, public property in the sum of 200 million. In laying the charges, the prosecution failed or neglected to take into account of the basic fact that it was part of 200 million that was used to construct the house at Saglemi. In other words, the value of the built environment is, in my considered opinion, a key determinant of how much of the total sum had been allegedly misapplied.
So Raymond, let me ask you, in such a case, do you think it is fair to charge someone with embezzling 200 million?
No.
When in fact, I cross-examined the representative from the Ministry of Finance, and I asked him, when you went on site, did you see structures erected? He said yes. So, and I asked him, so you agree that payments were not made for work, no work done? He said yes. So clearly we would have to quantify, value, in fact, conduct evaluation of what has been done, deduct it from the sum, and if there's indeed any loss, we'll know what is the loss and start from there. But you cannot
Would you be happy with that?
You cannot pin $200 million on one person.
Wait. So there's an undisputable fact which has been laid on this table, which is that there's the need to do some deduction, reconciliation, and settle on the actual figure lost, right?
If there is a figure lost.
My argument is that should not lead to the filing of nolli prosequi.
But that can lead to you losing the case. Yes, that can lead to you losing.
Because he doesn't want to the conversation. Let me say 2 minutes to you. Please make a point in 1 minute.
That should not lead to the filing of nolli prosequi.
Why not? Okay, that's what.
That should rather lead to the amendment of the charge sheet.
No. Okay.
Pending, that should lead to the amendment of the charge sheet. And so what I was expecting the Attorney General to do was to step back, do an amendment, do the quantification, so that in addressing us, if he was minded to do a nolli prosequi or possibly a withdrawal, right, he would have addressed us by saying that upon taking office, I've done a proper valuation and evaluation of the facts. I've come to the conclusion that no money was indeed lost.
Oh, okay.
And so I'm minded to discontinue or withdraw this charge. But he is saying that there's the need, with some work having been done, right? In a nutshell, there's the need for valuation to ascertain if indeed any amount has been lost, right?
Okay.
Now, if you get to know that indeed an amount of money has been lost, you are now coming to start the whole case afresh.
But why not?
But okay, so finally,
Raymond. One of the reasons for nolli prosequi is improper evaluation of evidence.
Okay.
So if you evaluate the evidence and notice that the evidence you have cannot support the charges, you can discontinue and come back.
All right.
The Attorney General said, I have evaluated the records. I have seen that some auditing needs to be done. So based on that, I have discontinued the case. But I have not forgotten about this matter. Where lies the hue and cry?
All right, the time is up. I think we should continue this conversation subsequently. And many thanks to you out there for joining me, lawyers Randolph and Nanaje Bafwa for also joining me. He's also a member of Parliament for Menchia South. And
my senior brother, as he prefers to be called.
Okay. Thank you so much for joining us.